everyone. This is
Thank you, everyone, for being here. Could you please take your seats and we'll get started? You're in for a treat today with our speaker, Josh Blackman. But before we get to talking about him, I'd like to recognize the members of the judiciary who have joined us today. We, of course, are going to be honoring Justice Christopher in her chambers, but in addition to Justice Christopher, Justice Peter Kelly is here. Welcome. Justice Russell Lloyd. And former Justice Martha Hill Jameson. And former Justice Murray Comer. We're so glad that you're all here. And as I said, today we're honoring the chambers of Justice Christopher. I'm sorry about this. Is that better? Who was appointed to the 14th Court of Appeals in 2009. She completed her undergraduate studies at the University of Notre Dame, graduated with honors, of course, and received her law degree from the University of Texas Law School, also with honors. She practiced law for 13 years at Sussman Godfrey and at Vincent and Elkins, and then spent 15 years as a judge at the 295th District Court before being appointed to the 14th Court. She has been honored by TACTIS, the Texas Association of Civil Trial and Appellate Specialists, for both being the Trial Judge of the Year and the Appellate Judge of the Year. And she's also received the Texas Bar Foundation Outstanding Jurist Award for her work as a trial and appellate judge. She serves on the Supreme Court Advisory Committee and the Pattern Jury Charge Oversight Committee. She's also active in her church and with the HBA's charitable programs, and we're so glad you're here today. Chris Connolly. Chris, would you stand up? Chris manages to tower above us even seated. Chris Connolly joined the 14th Court of Appeals in 2010. He graduated with honors from the University of Houston Law Center, where he was a member of the Law Review and is active in moot court activities. Welcome, Chris. We're glad to have you. And Ian Finch. Would Ian?
I am standing.
Ian practiced civil trial and appellate law for 10 years before joining the 14th Court of Appeals. He graduated from Georgetown University Law Center, where he also taught legal research and writing as a law fellow. He is board certified in civil appellate law and has served on both the State Bar Rules of Evidence and the Court Rules Committees. Welcome, Ian. We're glad you're here. And now I want to move to our esteemed speaker, Josh Blackman. To say that he is a prolific thinker, writer, opiner, speaker would be a gross understatement. I invite you all to take a look at his online CV to see the list of his publications and appearances and presentations. He's an associate professor of law at South Texas College of Law, where he specializes in constitutional law, the United States Supreme Court, and the intersection of law and technology. He's the author of 3 books, the first one in 2013, which was called Unprecedented, The Constitutional Challenge to Obamacare. The second in 2016, which is called Unraveled Obamacare, Religious Liberty, and the Executive Power. And then a book just released this month.
5 copies.
High copies available. Called An Introduction to Constitutional Law, 100 Supreme Court Cases Everyone Should Know. Josh was selected by Forbes magazine in 2014 for the 30 Under 30 in Law and Policy, and he has twice testified before the House Judiciary Committee on the constitutionality of executive action on immigration and health care. He's an adjunct scholar at the Cato Institute, and he is the founder and president of the Harlan Institute. The Harlan Institute is a nonprofit whose mission is to bring stylized law school experience into the high school classroom to ensure that our next generation of leaders has a proper understanding of our most fundamental laws. I read that. That's a quote from Wikipedia, that very impressive source. The Institute helps promote this lofty goal through a virtual Supreme Court competition each year for high school students, and through Fantasy SCOTUS, which is the Internet's premier Supreme Court Fantasy League. This is where students, lawyers, and anyone interested in doings of the High Court compete in predicting the outcome of cases. So I'm thinking about signing up. It's free. I already looked online, so y'all might want to do that. He also blogs at joshblackman.com. He's the author of over 4 dozen law review articles, and his commentary has appeared in the New York Times, the Wall Street Journal, the Washington Post, USA Today, and the LA Times, and many other national publications. Please join me in welcoming Josh Blackman.
So much. Thank you so much. I don't need this. Thank you so much, Linda and Margot and everyone else for hosting me today. My first time for the HBA, my first time at the Coronado Club, a beautiful room. We have an ambitious goal today, and I'll try and do it in less than an hour. The Roberts Court. Where are we, and where are we going? Last term began after a bruising confirmation fight. Justice Brett Kavanaugh finally took his seat. Actually, you know what? The plates are clinking. I will turn this on. Oops. There we go. Okay. Justice Kavanaugh took his seat after a bruising confirmation fight. And he filled the seat of none other than Justice Kennedy. Would this be a new, more conservative court? Not right away, at least. In a few high-profile cases, in fact, Justice Kavanaugh proved to be quite moderate. And indeed, Justice Kavanaugh, the newest member, has kept something of a low profile. Here's a fact for you. Justice Kavanaugh was in the majority 91% of the time. 91% of the cases, Kavanaugh was in the majority. Who else? Justice Gorsuch was not in the majority that many times. We're already seeing a schism between the two Trump appointees. In fact, Kavanaugh aligned more with Stephen Breyer and Elena Kagan than he did with Neil Gorsuch. Now, what about the chief, right? The new swing vote on the court. Well, Chief Justice Roberts, too, was in the majority a fairly large number of times, but not as much as Kavanaugh was. Do we have these sort of 5-4 decisions that split conservative-liberal? Not quite. In fact, in 4 cases, Justice Gorsuch joined the 4 progressive justices to make a majority opinion. We're seeing already that the court isn't, perhaps, as we thought it would be. All right, some more statistics if you like math. This year there were 66 rulings after argument. That's low, but 6 more than the previous year. 39% of the opinions were unanimous, 9-0. You don't hear that on TV, do you? 39% of the court's decisions were 9-0. And that's been the range for the last couple decades. Between 40 and 60% of the cases are unanimous. Most cases are not divided. The court reverses 74% of the time. Generally, if a case goes to the court, it's because you screwed up below, and they're going to reverse it. That's generally what happens. The Ninth Circuit keeps its crown with an 86% reversal rate. It's always there. But the state courts, sorry, judges, had an 82% reversal rate. So you are not quite the Ninth Circuit, but the state courts do not fare quite as well at the Supreme Court. Again, Justice Kavanaugh was in the majority 91% of the time. Roberts, 85% of the time. Alito and Kagan, 82% of the time. No one else broke 80%. Justices Thomas, Ginsburg, Sotomayor, and Gorsuch were in the majority 70% of the time. So generally, the court is not as sharply divided as you might think. In 5-4 cases, Gorsuch was in the lead 70% of the time. Kavanaugh was in the 5-4 majority 67% of the time. And Justice Thomas, 65% of the time. each justice wrote at least one 5-4 opinion, which is actually kind of rare. The last statistics are kind of fun, right? Who is most talkative justice? It used to be Justice Scalia, but rest his soul, he's no longer on the court. Now Justice Sotomayor has picked up that crown. She asked an average 24 questions per argument and asked the most questions in nearly half the cases. Next was Justice Breyer. He asked 19 questions. Judges don't argue, if you remember that. Judges ask questions. He had 19 questions per case. Gorsuch and Kavanaugh in the middle of the pack. Justice Thomas actually asked 3 questions this year. He's averaging 1 question every 3 years now. But when he asks a question, people pay very close attention to it. Okay. I'd like now to give an overview of some of the high-profile cases decided from last term. And these cases fall into a couple categories. First Amendment, property rights, criminal procedure, federalism, separation of powers, administrative law, political gerrymandering, or gerrymandering if you want to be cool, and, of course, abortion, which you can't go one term without having an abortion case. The first topic, again, is First Amendment. And the first case is called, I can't ever say this, Iancu versus Brunetti. Okay? Who's Eric Brunetti? He was a fashion designer who made a line of clothes, and the line of clothes is brand name spelled F-U-C-T. Pronounced exactly as it sounds. F-U-C-T. I will spare you pronouncing it. Apparently, it stands for Friends You Cannot Trust, but I'll let you take I'll let you take your word for it. He applied for a trademark with the PTO, which was denied because it was considered vulgar or highly offensive. The Lanham Act prohibits registration of immoral or scandalous marks. A few years ago, the court had a case called Metal v. Tam, where we had a band called the Slants. This was an Asian American rock band that was using the Slants as sort of an edgy name. They were denied their mark. The court ruled that they can get their mark because you can't have this sort of restriction on offensive speech. The court ruled for the FUCT brand by a 6-3 vote. They held that this ban on immoral or scandalous language violates viewpoint discrimination, and it ran afoul of the Metal v. Tam precedent. Justice Sotomayor dissented, and her argument was this goes too far. The government should not have to register every single offensive mark, and she was thinking of a racial slur. Would that be permissible to register? Think of the Washington football team, the Redskins, right? Could that be denied registration? But that was a minority opinion. The court at the present moment is very much pro-free speech. It's probably the most pro-free speech court we've had since the 60s, maybe. It's been a while. So this is one area where it's pretty consistent. And in that case, the dissenters were Sotomayor, Breyer, and Roberts, right? So this is not usual pooling of people who come together. But anyway, Justice Kagan wrote the majority opinion. Let's turn from the free speech clause to the establishment clause. It seems that this issue keeps coming back to the court, and they never have a good resolution. In 2003, we had 2 cases involving Ten Commandments displays. One from right here in Texas, which was Van Orden against Perry. You've been to the Austin Capitol. You have this ginormous, 6-foot marble slab, the Ten Commandments statue. Okay. In Kentucky, you had a much smaller one. It was this little framed portrait of the Ten Commandments on a piece of paper. The court split the difference. They said that the one in Texas was okay because it's been there for a while, it's big, it would be a problem to move it. The one in Kentucky, no good. It's new. It kind of came up in some dubious circumstances. Okay, that was precedent almost 15 years ago. Justice O'Connor's gone. We have a new court. Justice Kennedy's gone as well. This case is called American Legion versus American Humanist Association. In Prince George's County, Maryland, Bladensburg, you have this 32-foot Latin cross. It's just ginormous, right? It's just a cross, right? If you were driving fast, you probably wouldn't even notice it. It's in the middle of a traffic median, right? It's not in some sort of revered holy place. It's basically on the side of a road. It's been there for almost 100 years. It was erected after World War I to honor those from the community who died in the Great War. Some time ago, the American Humanist Society, which is an atheist group, challenge it as an establishment of religion. And they argue that this should be demolished, or alternatively, this was their recommendation, you could take the cross and chop the arms off, so it's just an obelisk. You're laughing, but this was one judge actually suggested this recommendation. The problem, of course, if you take a marble slab and you start smashing, the entire thing would just demolish. You can't do it, but that was a recommendation. The Fourth Circuit Court of Appeals actually held that the remedy was to take down the monument, to remove it. This was getting reversed. The how is more important. This case goes to the Supreme Court, and we have a 7-2 decision. Right? Now, 7-2 sounds great. Oh, wow, there's a lot of unanimity. They divide on the rationale. The upshot is the memorial stays. The downshot is we don't quite know what the law is. The opinion was basically about duration. This has been there for a long time. It didn't really bother anyone until recently. It would be a very big disruption to our society to tear it down. So we're going to leave it in place. But we're not going to clarify the doctrine. We're not going to reverse the beloved Lemon test, which I'm sure you all remember from law school. We're not going to adopt this test or that test. We'll just decide this case. So Justices Breyer and Kagan joined the majority to give 7 votes, but in the process, they basically watered it down, right? So like this iced tea, right? Where it's not quite sweet, but has enough in it to get you by, which is what all the court gives us nowadays. These sort of just boring rulings that don't really say anything. Justices Ginsburg and Sotomayor wrote very vigorous dissents, arguing that this is a cross in public property and it endorses religious content. But there were only 2 votes for that position. Okay. Let's go into property rights. The next case, I'm going to butcher this name. It's called Weyerhaeuser Company versus U.S. Fish and Wildlife Services. Involved the dusky gopher frog. This is one of those animals that basically doesn't really live in many places. In fact, it basically just lives in one place. And the question here is whether the Endangered Species Act prohibits designating private land as critical habitat when that habitat is not essential to the species conservation. In other words, the animal doesn't actually live there, but the government designates this land as critical for the animal anyway. The court ruled against the government here, and they said that private property can only be designated critical habitat if it's actually the habitat for this species, okay, which I think makes some sense, but environmentalists probably didn't like it very much. The next case is a property rights case involving eminent domain. We have some state judges here, I'm sure you know. If you have a problem with eminent domain or the government taking your property, you have to go to state court. There is a doctrine called Williamson County, which basically says if your property is being taken, you can't go to federal court first, you must go to state court first. But of course, if you go to state court first, there's preclusion, which means the federal court's bound by the state court. The upshot of Williamson County is it's almost impossible to get a federal takings case into federal court, even though it's a federal constitution. Williamson County the next case wanted to overrule Williamson County. It was called Nick versus Township of Scott. What were the facts there? Kind of spooky. You had a woman, Rose Nick, who had a cemetery in her backyard. This is common in Pennsylvania. And the state passed a law that required all cemeteries to be open to the public during daylight hours. Now, this was in the woman's backyard. She said, no, I don't want to keep my cemetery open to the public during daylight hours. It's just a backyard cemetery. And then she was fined for not complying with the code. Okay? She went to court, and the state court dismissed the claim. Then she went to federal court, and the federal court ruled against her, says, no, you have to go to state court first. She was basically trapped. The court basically overruled Williamson County. And they said that because the takings clause is like any other right in the Constitution, it should not be limited to state court. As a result, Ms. Nick can now go to federal court to seek her remedy. This was a 5-4 opinion written by the Chief Justice when she overruled a precedent. And Justice Elena Kagan wrote the dissent, and she said that this is no good, that this ignores the principles of stare decisis. And she said, who knows what precedent the court will overrule next? She actually knew, so it's kind of just like, it's it's kind of like, who knows? But she knows, because she knows what's coming down the pike. But she's giving us a little preview of things to come. Okay. that's it for property rights. Let's go on to criminal procedure cases. The first case I want to talk about is called Timbs versus Indiana, TIMBS. This is a case involves criminal civil asset forfeiture, but criminal justice reform. Make sure I get that right. As I'm sure you know, if a person's arrested, the government can then seize property that might have been used to facilitate that crime. But is there a limit on what can be seized? In this case, you had a small-time drug dealer who was sentenced to home detention and probation. He was dealing drugs out of his $40,000 Land Rover. The drugs sold were not worth $40,000 by a long shot, yet the government seized his vehicle. And he argued that the seizure of his vehicle violated the Eighth Amendment's prohibition on excessive fines. Now, you may not know this, but the Supreme Court had never held that the states were limited by the excessive fines clause. It wasn't what we say incorporated. It had just never been incorporated. So Timbs goes to the Supreme Court and says, incorporate the Eighth Amendment. Now I know he wins, right? All the justices agree that the excessive fines clause should be incorporated. Unfortunately, that doesn't mean he wins, right? The mere fact that the clause is incorporated doesn't mean that the fine was excessive. And now it goes back to the state court where he'll probably lose. But at least he had a good show for a little bit. Okay, so that's Timbs against Indiana. The next case involves double jeopardy. Now, you all know the Constitution says that you can't be tried twice for the same offense. Right? So the federal government prosecutes you and you're acquitted, they can't prosecute you again. Right? That's how double jeopardy works. But what about the state government? Right? If the feds convict you, can the state government come in and convict you again for the same offense? Now you might say, of course not, Josh, that's double jeopardy. Well, not quite. The courts have developed something called the dual sovereigns doctrine. The dual sovereigns doctrine, which says when two sovereigns are prosecuting you, they can prosecute you twice for the same offense because it's actually the same offense. Gamble versus the United States asked whether the dual sovereigns doctrine was unconstitutional, whether to overrule this exception to the double jeopardy clause. By a 7-2 vote, the court said no, right? Again, it was 7-2, it was not 5-4. That a crime under the laws of one sovereign is not the same as a crime under the laws of a second sovereign. Therefore, there's no double jeopardy problem. Justice Thomas actually concurred and said, I thought about this issue, but I think this is right. Justice Gorsuch dissented and said that this is inconsistent with the text and history of the Constitution. So we see the schism between Thomas and Gorsuch on originalism, which I think is a wonderful thing to see. Justice Ginsburg argued that the United States and the states are one sovereign and that this entire exception makes no sense. That was a 7-2 decision. Okay. Next, let's do some federalism cases. The case I want to talk about is called Tennessee Wine and Spirits Association versus Thomas. Now, the second I say wine and spirits, you know what this is about, right? Dormant Commerce Clause. It seems almost every year the court has some case in which the state has regulations about alcohol. We all know the 21st Amendment to the Constitution repealed prohibition. Yay, right? But the 21st Amendment also reserved the rights to the states to regulate alcohol in certain unique ways. And states have special powers to burden the transportation of alcohol that they cannot burden other commodities. Right? Generally, states cannot limit commerce in other states. They can't block imports. But the 21st Amendment gives them some powers. Tennessee had a crazy law. It said to have a liquor license, you have to live in the state for 2 years. And you have to have all the shareholders live in the state. In other words, you cannot have out-of-staters run liquor licenses, which is insane, right? If I moved to Nashville and I wanted to open a bar, I could not have a liquor license unless there was someone who lived there for 2 years. The court ruled by a 7-2 vote that this 2-year residency requirement violates the Commerce Clause. This is out-and-out protectionism, the court says, and it violates the Constitution. Justice Gorsuch, with Justice Thomas, wrote a dissent. And they argue that the 21st Amendment gives states this additional power to burden commerce from other states, sort of like a carve-out. So again, Gorsuch and Thomas are idiosyncratic. They are not fitting into any normal bucket, and they sort of go their own way in all of these cases. Okay. Next, I want to turn to administrative law, which you might think, oh, boring, Josh. Admin law is important. Almost all law today is created not by Congress, but by agencies. Everything that affects your life is done by some bureaucrat who you'll never vote for in your life. So the admin cases have a significant salience in how we go about our daily lives. The first case is called Gundy. Gundy, G-U-N-D-Y versus United States. The facts aren't the best. You had a person who was a sex offender, but he was convicted some time ago, before the enactment of SORNA, the Sex Offender Registration and Notification Act. I think I got that one right. Yes. He was convicted before SORNA. SORNA gave the Attorney General the power to specify who is subject to the reporting requirements who were convicted before the act. In other words, if you're convicted after the act, it's easy. You're convicted, right? But if your conviction was before this federal law, the AG can specify who the law applies to. Mr. Gundy, who again was a sex offender, challenged it. And he said that this delegation of authority is unconstitutional, right? That Congress needs to give the AG more guidance on who to make subject to this serious, it's not criminal, but it's basic criminal, this serious prohibition. This case was argued the first week of the term. You might recall Brett Kavanaugh had not yet taken the oath yet because he had to have a second hearing with all the other stuff that happened. As a result, he had a shorthanded bench. He only had 8 members. The court split 4-1 to 3. What the hell is that, right? What does 4-1 to 3 mean? Well, there were 4 votes. Justice Kagan wrote the plurality saying that this statute was fine, that the delegation had what was called an intelligible principle, that there was enough guidance to the AG to know what to do. There were 3 votes. Gorsuch, Roberts, and Thomas said, no. This violates the non-delegation doctrine, right? Congress needs to give more guidance. This was the first serious opinion of the court in 70 years, saying that you have non-delegation problems. And then what about the 8th vote? We have Justice Alito, and he did a funny thing. He said, well, I don't really like the dissent. I don't like the majority either, but I'll go along with the majority here because I'm not going to make a huge ruling when there's only an 8-member court. But if there's a majority later that wants to consider this issue, I'm game. So Alito basically gave a 5th vote in judgment so that there was a majority opinion, but says, yeah, just for now, not later, guys. Fun fact, the Gundy case was decided in June. The petitioners, Mr. Gundy asked for a hearing, which is almost always denied. And just last week, the court granted, they relisted the case, which means that the case is not over yet. So it might actually have some sort of dissent from denial, who knows. So this case is not dead. And let me tell you, there are other vehicles that may raise delegation issues. So if you buried delegation in your mind from law school, dig it up and come to my class. I will help resurrect it. We talk about it in my classroom. The next case, it sounds boring, but it's not. It involves what's called Auer deference. That's A-U-E-R, not H-O-U-R, A-U-E-R. Okay, what were the facts? You had James Kaiser. He was a Marine who served in Vietnam. And he sought certain benefits for his PTSD. The VA denied certain benefits, but that denial turned on a meaning in a regulation, the meaning of the word relevant, right? What was relevant information? The agency said, well, the word relevant is ambiguous, so here's our understanding of the word relevant. And the court said, you know what? We agree that this term is ambiguous. Therefore, we will defer to the agency of how they interpret their own term. This is not Chevron deference. You've heard of Chevron deference. Chevron is when you have an ambiguous term in a statute, and you give deference to the agency to interpret the statute. Our deference is different. With our, you have an ambiguous word in a regulation, and the court gives deference to how the agency interprets its own regulation. All the justices agreed that Mr. Kaiser should win, so I'm sure he's happy about that. But they split basically 5-4, or I guess, 5-4-ish, 5 to 4-ish, good enough, on whether to overrule our deference. The majority was by Justice Kagan, and she said, no, let's stick with our deference. Stare decisis, we should stand by our principles. And you had Gorsuch, Thomas, Alito, and mostly Kavanaugh, I say mostly Kavanaugh, who said, no, we should kill our deference. And then you had the chief, and the chief says, no, we don't need to overrule our deference, but we should really kill our deference, right? We should radically alter how it works, but we'll keep it in name only, right? This is the court we have now. Let's not overrule the press, let's just completely change it and call it something else, right? So instead of our deference, then we have Kaiser deference, like a Kaiser roll, I don't know, or Kaiser Wilhelm, whatever you want to say. We have Kaiser, it's K-I-S-O-R, but we have Kaiser deference, where the court radically altered how this deference doctrine works. Okay. The next case is a weird one. Department of Commerce against New York. This case was such a waste of time. There was so much wasted for just nothing in the end. We have a census every 10 years. The Trump administration announced that it wanted to add a question to the census. The question was, are you a U.S. citizen? Okay, so let's get the basics out. Does the government have the power to ask if you're a citizen? Of course they do. In fact, on some of the smaller census forms that go out, not smaller, but like with smaller distributions, they always ask the question, are you a citizen? But there was fear that if you send this out to a lot of immigrant communities, people say, uh-oh, I'm not filling this out. I don't want to flag myself as a non-citizen. And as a result, this question might suppress response rates among certain demographics, primarily Hispanics and immigrant communities. Okay. Now, generally, does the government need to get the court's permission to modify the census form? Usually not. Usually the government does whatever they want, no one cares. But here, a number of groups and states challenged the government's decision. And they argue that the addition of the citizenship question was irrational, that it violated the APA, the Administrative Procedure Act, that was arbitrary and capricious. The government gave a rationale of why they collect this information. The rationale they gave was that they needed it to help enforce the Voting Rights Act. I chuckled a bit because by this point it's almost a joke, right? They need this information to enforce the Voting Rights Act. That wasn't the reason. Everyone knows it wasn't the reason. The reason was they wanted to have this question to, let me take a step back. When congressional districts are drawn, they're drawn based on total population, right? So in Harris County, we have congressional districts. It's not based on who can vote. It's not based on citizens. It's based on the total population. A long-standing goal of some conservatives to change that is to draw congressional districts based on voting age population who's a citizen. If you do that, cities shrink in representation and suburbs grow. Texas, I mean, Harris County would just probably lose a couple members of Congress, like maybe Sheila Jackson would be out of a job, right? That's probably what would happen. Okay. Why does this matter? In order to draw the districts based on citizenship, you have to have the data somehow. Now, the government can probably do it already, but the thinking was, aha, if we have this question, we'll now know on a block-by-block basis who is and who's not a citizen, and we can draw districts differently. That was the reason they did this, and we have evidence galore about this. But they said, no, we have to do this for the Voting Rights Act. This goes to the court. And there's some evidence that, once again, Chief Justice Roberts changed his mind at some point. It seems this happens to him quite a bit. He's like, very conflicted. So the first part of the opinion, Roberts says, of course they can add this question, right? It's within their authority. So he basically rejects all the other arguments raised below. But we get to the Roberts roller coaster. We sort of change his direction in one second sentence, right? He says, but the rationale they gave at the Voting Rights Act doesn't really make sense, so therefore they can't do it. So Roberts basically said what was given was called a pretext, right, where the rationale asserted was not the real reason. But Roberts said, but you guys can cure this, right? Of course, if you give the real reason, come back to us later. The only problem was Roberts decided this in June of 2019. Okay, the census has to be printed that month. So there was a brief period where it was like, oh my God, are they going to go back to the court with another justification? And there were some hints the administration would keep fighting, but eventually they caved. They said, we can't do it. And they surrendered. So your citizenship question will not be on the census. Okay. All this for basically nothing. But they'll still get this information, and the next case will be, can Texas draw its districts based on population, based on citizenship, not total population. That will be a much bigger case. The court punted that issue a couple of years ago in a case called Evanwell. This will come back to the court. I'm not confident. I think Texas will win this one, and that will radically change how the electoral map works for congressional districts. Okay. Next, more politics. Gerrymandering, or gerrymandering if you want to be cool. For years, we've known that districts don't really make sense. They're drawn in these sort of zigzag fashions to maximize one demographic. If you look at some of the districts in Houston, you have some of the districts in Austin that go down to the valley. They make no sense. Okay. We have a lot of cases about racial gerrymandering. That is, where districts are drawn to suppress, say, the black vote or the Hispanic vote. That's so old school, right? Now we have political gerrymandering. Instead of suppressing minority vote, we suppress Democratic votes in red states. Or in blue states, we suppress Republican votes. So we have two cases, Rucho versus Common Cause from North Carolina, in which the Republican-controlled legislature, basically gerrymanders and Democrats out of office. And you have Lamone versus Bensonek, which is from Maryland, in which the Democrat-controlled legislature got rid of Republican members. It's the same thing on both sides. The fact that they were both red and blue in this case made it a little bit easier for the court. But the question was this: could the court declare a political gerrymander to violate the Constitution? Right? Was there some principle in federal constitutional law that will allow courts to rule that none of this gerrymander goes too far? This issue came to the court before in a case from Wisconsin. Justice Kennedy sort of punted, saying, well, maybe, but not this case. Came back to the court this year. We have no Kennedy. The court ruled 5-4. This is a non-justiciable political question. That is, the courts do not have the means to determine if, in fact, this gerrymander is valid. So it's up to you guys. You figure it out yourselves. Justice Kagan wrote a blistering, very angry dissent. And she said that this imperils our government. That if people can now, if members of government can now structure who's elected, then the political process can't check this abuse. So I think we'll see more of these political gerrymanders, except state courts will intervene. So the North Carolina courts have already held that the state maps are unlawful. So I think in some states where you have courts that are receptive, you'll have success. In other states, you won't. So this will not be a matter of federal law anymore. It will be a matter of state law. Okay. The last big issue from the prior term I want to talk about is, of course, abortion. Now, the court didn't actually have any argued abortion cases. They had one which they resolved kind of quietly. And it was called Box versus Planned Parenthood of Indiana. Indiana enacted a couple laws. One, the first part of the law said that fetal remains were not going to be treated as a surgical byproduct, the same way you would treat it like a removed tumor or something. They had to be disposed of in a, quote, humane and dignified fashion. Texas has a similar law that's going through the courts now. The second element of the law banned abortions based on sex, race, and disability, which was far more significant. Surprise, surprise, the court didn't touch the second law because the Court of Appeals hadn't considered it. So the court dodged the actual issue that people care about, the actual ban on abortion. But they upheld the law concerning disposal requirements. And they said, well, the state's law has a legitimate interest and it was rationally related. This was an unsigned per curiam opinion. There was no argument, and it was done very quietly. If you ask me, this was some sort of really tough compromise between Roberts and Kagan and Breyer to avoid adding an abortion case to the docket. Ginsburg dissented, says that this violates the undue burden standard from Casey and will use a higher level of scrutiny than rational basis. So Roberts kept him in the headlines one more year. All right, let's move forward. Next year, this year, the term already started a week ago, is shaping up to be exciting, if you want to use that word. The court will hear cases striking at the heart of the culture war in so many cases. Let me walk through a bunch of them. One of them is called Ramos versus Louisiana. Okay? What's Ramos versus Louisiana about? In Louisiana, the law was quite different. Generally, you have a 12-member jury, and to convict, you need all 12 members. Louisiana allowed a conviction with only 10. Louisiana and Oregon were alone allowing 10-member convictions. Now, the Constitution doesn't actually say you have a right to unanimous jury verdict, but the courts have said you do. This is another incorporation case of whether the right to have a unanimous jury conviction is incorporated. The second case, also criminal law, involves the insanity defense. Kansas tried to abolish the insanity defense by statute. This case will see whether the 8th and 14th Amendment allows the state to abolish the insanity defense. The next criminal case involves Bridgegate. Remember this one with Governor Chris Christie's administration. If you've ever been to New York City or Fort Lee, New Jersey, you have a bridge called the George Washington Bridge. And there's a lot of traffic on this bridge. I've crossed it many times. And Christie's associate, her name was Bridget Kelly, basically shut down some lanes in the bridge to punish the mayor of Fort Lee, New Jersey, who refused to back Christie. I mean, this is garbage politics for sure, but does this violate federal law? And the Supreme Court agreed to take this case. Her conviction is getting reversed, so I think she's going home. Maybe she'll take the other bridge, maybe she'll take a tunnel. Let's talk about guns. The court agreed to hear a case called New York State Rifle and Pistol Association versus City of New York. The court has not reviewed a Second Amendment case in nearly a decade. In 2008, the court held that the Second Amendment protects a right to bear arms in the home. And in 2010, the court said this right also limits state power, not just federal power. But they've kind of stayed away for a decade. Well, now we have a new court. And Justice Roberts, maybe he's a swing vote, not Justice Kennedy. This case is almost so narrow it doesn't matter, right? It raises the question of whether you have the right to keep a gun outside the home. But New York's law was so precise. It said you had to keep the gun locked in a case, unloaded in your trunk. And you can only drive to 5 ranges in the city. You couldn't go to New Jersey, for example, to a range. This law was almost certainly irrational. It made no sense to have that many restrictions. As a result, New York repealed the damn law. They said, no, we don't want to lose. We're going to repeal the law. So there's a good argument the case is now moot, that there's no live controversy anymore, which I think is probably the right answer. There are other cases in the pipelines. What the court may do is argue this case out, dismiss it as moot, and then grant another one, which I think is very likely. But this case is on the docket for argument at least. Next big cases were just argued this past week. They involve the question about the Civil Rights Act of 1964. The Civil Rights Act of 64 makes it a prohibition to discriminate because of sex. Because of sex. Does this nearly half-century-old statute prohibit discrimination against gays and lesbians and transgender individuals? The argument was last week, and I don't know that it's open and shut which way or the other. I think the justices are grappling with it. You may say, well, of course, in 1964, it was a crime to be homosexual, and homosexuality was a disease recognized by by doctors. How could it possibly be the case? And my goodness, transgender wasn't a thing. It's very often the case that the words people use do things they don't intend. We say things sometimes and don't quite realize what we're saying that might go further. So maybe because of sex has a broader interpretation than those in 1964 intended. We'll see what the court does here. In any event, I think Congress will tidy this up if the court doesn't. So it's either a question of now or later. But I think this issue is probably going to disappear in the next couple of years, one way or the other. Next, let's do immigration. A huge case involving DACA. This is deferred action for childhood arrivals, a Obama-era executive action that granted deferred action and lawful presence to certain aliens who are minors in the United States. President Trump tried to rescind the policy, and then courts across the country said, no, you can rescind it, but the reasons you gave is inadequate, somewhat similar to the census case. Now, the Supreme Court granted review, and we know when the court grants review, they usually reverse. So I think there's a very good chance the court reverses and lets Trump wind down the policy. This creates a huge political headache, but I think this should be resolved politically and not by the courts. Next, intellectual property cases. These are kind of fun. There's one case involving pirates. Yes, actually pirates. Allen versus Cooper. Blackbeard's pirate ship, Blackbeard, right, sank off the coast of North Carolina. And this guy, Allen, found the wreckage, and he recorded some videos of the wreckage. The North Carolina government started using his materials without giving him any payments for royalties. So he sued them for violating the Copyrights Act. Well, usually you can't sue a state, can you? 11th Amendment. So the question is whether the Copyright Remedy Clarification Act allows suits against the states. Not a very high-profile case, but I think if I was Blackbeard, that's kind of cool. Another one, which is kind of low profile but important, called Georgia versus publicresource.org. Who owns the law, right? In Georgia, the Georgia Code Annotated has a copyright attached to it, right? Lexis can publish it. In other words, I can't freely access and reproduce the laws of a state. Now, Lexis says, well, we provide annotations, those little head notes. So the question is whether these sorts of government edicts, these laws, are uncopyrightable. This could have big implications for Westlaw and Lexis. Let's talk about school choice, right? Espinoza versus Montana Department of Revenue. This case involves funding of religious schools and whether the state is allowed to exclude religious schools from a general tuition grant policy. We have one of these cases, it seems, every couple of years. Last case, and I'll take some questions, involves, of course, abortion, right, every year. This is a case from a neighbor next door, Louisiana. June Medical Services versus Gee. You'll recall Texas had a law called SB 2 that imposed restrictions on abortion clinics. For example, they had to have, doctors had to have admitting privileges. That is, they have to be able to check into a hospital somewhat nearby. And also all abortion facilities had to meet surgical standards, even if the facility didn't perform surgical abortions. They only prescribed medicine. Okay, court said that was unconstitutional. Louisiana said, okay, let's try it a little bit differently. Let's have the admitting privileges law, but we're not going to have the surgical standards law. This went to the Fifth Circuit. Fifth Circuit upheld and said, this is different than the Texas one. I will leave to you to judge whether there's actually a distinction. I think it's a thin one, but the court upheld it. Supreme Court, at that point, Louisiana was about to shut down the clinics, and there was an emergency stay application. The Supreme Court, by 5-4 vote, granted a stay, so the clinics stay open for now. In fact, Chief Justice Roberts, we can count, was in the majority. Now we have a cert grant, and the question is whether the Louisiana law will be upheld. The court might say, yes, this is different than the Texas case, or they might overrule the Texas case because Justice Kennedy is here no longer. I don't know what they're going to do, but if this does happen, then a number of clinics in Louisiana would probably have to close down. But this would be the first big abortion case since Justice Kennedy's retirement. 1250, how's that? All right, I'm done. I will take your questions. Thank you all so much. Thank you. Yes?
I know this case doesn't come up in the Supreme Court, but I'm sure it's going to be a cert app eventually on the Affordable Health Care Act.
Oh, yeah. Yeah, yep.
When do you think that might come before the Supreme Court, and what's your prediction on what Roberts or the court might do?
Well, I know John Roberts always disappoints me. That's what he does every year. He finds new ways of doing it. It surprises me how he disappoints me, but he'll disappoint me. The question was about the ACA case, which I now have 2 books on and a 3rd coming soon. It's a gift that keeps on taking. In 2012, the court upheld the Affordable Care Act. And Chief Justice Roberts said that the individual mandate to buy insurance is unconstitutional, but the ACA as a whole could be read as imposing a tax on the uninsured. Because the ACA can be read as imposing a tax, we uphold the mandate. Okay. The way I describe it is that the ACA was surviving, dangling by a thread. And in 2017, the Republicans cut that thread. They repealed the penalty, right? The penalty that raised revenue was reduced to $0. As a result, the saving construction falls, and the predicate of the Chief Justice's opinion no longer exists. Most people will agree to that. That part's easy. The harder part is what do you do to the rest of the law? And that is something that implicates severability doctrine, right? Which I think is actually a much harder question than people have given attention to, because our severability doctrine is an absolute mess. It doesn't make a lot of sense. My prediction on the Fifth Circuit, we'll probably get a decision at some point in the next month or two. Why do I say that? Because in order for a cert petition to be timely reviewed, it'll have to be filed by November or so. So I think we'll get some movement on it very soon. I think the clerk's going to have an awful Thanksgiving, and I think that's what we're dealing with. My prediction. Thank you for the question. Yes, ma'am.
There was an Oklahoma Native American rights case that was argued this term.
Oh, yeah.
A decision carried over to this term. Procedurally, what does that mean?
Oh, God. I'm going to have to pass. I'm blanking on that one. I'm really sorry. Like, I know the case, but just I can't remember the facts.
I'm just procedurally.
Has it been relisted for argument?
I think so.
Then it should be re-argued. Yeah, I'm not sure. I'm really sorry.
Okay.
Thank you. Yes.
In your reading of the Supreme Court, have you got any kind of sense for this current court's view on kind of error correction or GVR practice? Sometimes you'll get a circuit that will go to Supreme Court law and just decide not to follow it. It's not a huge issue, but for practitioners, they do take a small amount of those cases. Have you got any sense of how they feel that with that function?
Yeah, so the question was about what's called GVR, grant, vacate, and remand. Very often the Supreme Court says we are not a court to correct errors, except when they correct errors. And they've developed something called the shadow docket. It's called the shadow docket because these are cases that are not argued or decided on these single one-page per curiam orders. For example, the abortion case I mentioned from Indiana, there was no argument. That was a GVR, right? So the court does these quite often. And I think they do this to avoid having a controversial ruling. Say, okay, well, we don't want to take this, but just send a signal you guys screwed up. And I think you have to read these very carefully. The court's been very willing to do these over the last couple of years. Questions? Yes, sir.
Two questions, but they're going to be fast and easy for you. In the eminent domain case you mentioned, is it really the law that if you have a takings case, you can start out in federal court, or was that plaintiff able to do so only because it had been rebuffed in state court? The second question is, in your introduction, I heard you wrote a book about 100 Supreme Court cases everybody should know. I'd like to know what your favorite is and where you would rank my favorite, West Virginia Board of Education versus Barnett.
Okay, well, let me take the second question first. The new book is out called 100 Supreme Court Cases Everyone Should Know. Go on your phones and Amazon. You can order it right now. I'm serious. It's been sold out for the last month. We finally got copies in stock on Amazon, so get them all you can. Barnett's a wonderful case. If there's any fixed star in our constitutional constellation, no one should be told what to do. It's actually not in our book. There are a lot of really hard cases. I have a hard time picking one. I think they're all wrong in some regards. There are very few cases I think that were absolutely correct, but there's one thing that is absolutely correct was Barron v. Baltimore. I think Marshall nailed that one. Everything he said was correct. The Bill of Rights does not apply to states. Beyond that, I think all these things are wrong. The first question was an eminent domain. The Nick case involves what's called inverse condemnation, right? Eminent domain is where the government says, we want to take your property, Josh. We are going to go to state court, and we're going to seek a taking against you. That is still happening in state court. The Nick case is different. Nick is when the government regulates your property, and you, the property owner, say, you know what? This regulation amounts to a taking. I want compensation. That's why it's inverse condemnation. Now you go right to federal court. But eminent domain will usually begin in state court even after this decision.
But inverse condemnation,
yes,
can begin in federal court?
Yes, in fact, there have been some that have started already within federal court. This is a huge difference because there is no federal case law on inverse condemnation. It's going to be actually a brave new world for property rights lawyers. But good question, thank you.
It's really just dependent on which governmental authority.
Who starts it, right? If the government's taking your land, you start off in state court, right? They go to the local county court. But if the government regulates you and you want to challenge that as a taking, you can go right to federal court now.
Even if it's the state is trying to regulate.
Yep. So you say it's a violation of the Fifth Amendment. You're seeking compensation. In other words, you can't stop the regulation, but you want money for it, which the government doesn't want to pay you. I also teach property law, which is somewhat conversant. Yes, sir.
While we're on that topic, I know the Texas Supreme Court, I think, touched on this issue or maybe addressed it, and I just haven't paid attention, but is it possible to take private property? I don't know if that's something that,
What do you mean? All property is private.
well, I'm sorry, not private, I meant personal property as opposed to real property. Like an improvement or something on someone else's real property.
You know, I don't know.
Okay.
It's a good question. I'm not sure. Your Honor?
Aren't the cases against the Corps of Engineers based on the flooding?
Yeah.
That's inverse condemnation.
Yes. Yeah.
'Cause they-
Those are federal actors, though, so it's appropriate to go after them in federal court, right? This is a local issue in Houston. If you remember, after Hurricane Harvey, the Army Corps of Engineers released the waters in the reservoirs, and they flooded many people in their homes. The question is whether that flooding amounts to an inverse condemnation, right? Because it was temporarily occupied by piles of water.
Inverse, why is it just taking?
Taking is when the government comes at you first, right? That's what I think of, like Kelo, right? Where the government says we want to take your house and turn it into a warehouse or a facility, right? That's condemnation. Inverse is where the property owner brings the suit seeking compensation for a taking, right? In the first category, the government says, yes, we are taking your property, we want to take it. Here the court says, no, there was no taking, we didn't take your property, we just flooded a little bit, right? And the property owner says, yes, you took my property, you got to pay up for it. That's the difference between condemnation and inverse condemnation.
What about the dam cases? The dam cases.
That's D-A-M-M? No, D-A-M.
The dam
Yeah.
cases, which started this whole law back in the turn of the century, when they built a dam, the rivers will flood the land, and that is a taking, the permanent taking. Then they evolved it to temporarily take,
Yeah.
And, I think that's where we are now.
Yeah, exactly. Right. Again, when the government wants to say take your land to build a road or a highway, right? Or they want an easement across your land to build a power line or a pipeline, right? That's called condemnation. They're saying, yes, we are taking your property and we're going to pay you whatever we're going to pay you, right? The flip side of that is where the government does something to your land and won't own up to it. They won't admit it. They say, no, we're just regulating your land. And you say, no, you took my property, you got to pay me for it. And at that point, the plaintiff, the property owner, goes to the court himself and seeks compensation for that suit. That's called inverse condemnation. Not very important, but the regular condemnation cases are stuck in state court, but inverse can go to Fed court. Yes, sir.
You mentioned that the New York pistol rifle case
Yeah.
might have dismissed me.
Yeah.
Another one. Do you know of any candidates that might be granted?
Jersey, go across the Hudson, right? There are cases from New Jersey about rights of carry. There's another case from Maryland about concealed carry. There are plenty of cases if the court wants to take one. The reason why the New York one was attractive was it wasn't the right to conceal carry. It was keeping a gun locked in your car in a box without the ammo. I mean, it's like the most trivial law you can imagine that's completely irrational. It's like the government actually said, we were afraid people would pull over during road rage, take the gun out of their box, start shooting people. It's insane. That's why they repealed the law. It was completely irrational. Are we done? Thank you. Anyone else?
You'd be happy to entertain other questions.
Thank you all so much.
Let people know that you are free to go.
You're free, you are free to leave. I will not condemn you any longer.
No, but
You can inverse yourself out.
but I also want to
No compensation either, though.
I also want to apologize to Justice Jerry Zimmerer, who came in late, and I did not see you. And welcome also to
Thank you, sir.
This was a wonderful presentation.
Thank you so much.
I hope that I'm going to be on SCOTUS, Fantasy SCOTUS.
We'll see you there.
So
Thank you so much.
join us next month. We will be back to our second Thursday instead of the Friday.
I teach on Thursdays.
Yeah, we
Thank
hope
you.
to see you.
Thank you so much, Linda.